it's winter and you're 40 kilometers outside of Dawson Creek and you've spent some time at Chance's Casino there. You had a few drinks and you're driving home back to the farm. And snowy night, you lose control of your truck and you put it in the ditch, and a police officer's a kilometer away driving your direction and sees your lights as you end up in the ditch. And so they fire on their emergency lights and come driving up, and they're talking to you and dealing with you there at the roadside, maybe arranging a tow truck to try and get your truck pulled out. And at that point, they detect an odor of liquor on your breath and say, were you at Chance's Casino earlier? I think I saw your truck there. And you say, yeah, I had a few beers there. And so the police officer makes a demand that you blow into a roadside breath tester, an approved screening device. And you blow into that device and you get a fail. And a fail on an approved screening device in Canada is supposed to mean that your blood alcohol concentration is over 80 milligrams. But in BC, they're actually programmed at 100 milligrams in 100 milliliters, so 0.1. And so the police officer at that point says, well, now on the basis of this fail on this approved screening device, I now have reasonable and probable grounds to conclude that you've committed the offense of having a prohibited blood alcohol concentration within the 3-hour time after driving, and driving while your ability to operate a motor vehicle was impaired by alcohol. And so the officer then tells you, I'm detaining you because of those criminal offenses that I think you've committed. And then the officer tells you about your right to talk to a lawyer. And then the officer says, okay, pursuant to the criminal code, I'm hereby making a demand that you provide a sample of your breath as soon as practicable into an approved instrument to determine whether or not your blood alcohol concentration is over 80 milligrams and what your blood alcohol concentration is. And so at that point, okay, you're arrested, you're detained, and you're driving back to Dawson Creek, and suddenly a deer runs across the road. Deer runs across the road, and the police cruiser strikes the deer. And the deer comes up, hits the windshield, and the cruiser can't be driven anymore. The police officer's pretty shaken up, and you're in the back seat going, oh, wow, now what happens? Okay, am I still under arrest? And so the officer calls another police cruiser to come out, and that takes some time. They have to drive all the way from Dawson Creek, and then they got to drive you all the way back to Dawson Creek from there. When they get you back to the detachment and you phone a lawyer, you're probably trying to call Kyla Lee because she's the king of the impaired driving lawyers. Maybe you want to call me, or maybe you just want to call some lawyer who you trust to advise you in those circumstances. And you make that phone call. That takes some time. And ultimately, you provide samples of your breath, and you blow into the approved instrument at 3.5 hours after the time you were driving, and you blow 70 milligrams the first time, and you blow again, and you blow 60 milligrams, so 0.06. You're under 80, and you're thinking to yourself, man, I won the lottery. I lost all my money at Chance's Casino. But look at this. I'm not going to end up convicted of having a prohibited blood alcohol concentration, not being over 80 milligrams. And so the police officer's scratching his head, thinking to himself, what's he going to do? But he releases you with a court date, and you have to go to court. And it turns out you can still be convicted in those circumstances, because if everything else has been done correctly, the police in Canada are allowed to rely on a bunch of presumptions. And one of the presumptions is that they get to add 10 milligrams per hour to put you back into a window. So the window is in the 3 hours after driving, your blood alcohol concentration was at or over 80 milligrams in 100 milliliters. And if it's outside of that 3-hour time, they can add 10 milligrams per hour. It's just by operation of law is added 10 milligrams per hour. So if you're at 3.5 hours, they can add 10 milligrams for the hour before that, 10 milligrams for the hour before that. And at that point, you're over 80 milligrams during that 3-hour window after you operated a motor vehicle. Now, this is contingent on a lot of other things, right? This is a warrantless search that is only permissible when it's authorized by law. Authorized by law is it's got to comply with the requirements of the criminal code. But if they do comply with all of those requirements in the criminal code, the prosecution enjoys the benefit of this presumption and gets to add this 10 milligrams per hour onto your reading to get you up to 80 milligrams in 100 milliliters within that 3-hour window. So it's a funny thing. You're thinking to yourself, when you're in the backseat of that police car, that deer just gave its life to keep me from being convicted. But in fact, you can still be convicted of the very same offense because they get to add this extra alcohol onto your reading, basically adding 10 milligrams. Now, there's problems with that. There's some problems with the government deciding to do that, but that is what the law is right now, and it's a weird thing, but that's the way we do it in Canada.